welcome you all participants for this highly instructive webinar. Usually in our webinars, we cover topics which are purely technical in nature. Today, we are going to depart a little bit from our usual style of webinar. We are going to cover a subject which is techno-legal, and it is extremely important for all of us who are practicing as structural engineers. The topic of the webinar is professional indemnity insurance in project development. How does it cover structural engineers? And speaker of the day is Mr. Puba Mahalingam from Singapore. I welcome you, Mr. Puba. I also take this opportunity to welcome our president, Mr. Manoj Mittal, in the panel. Welcome, Manoj.
Thank you. Welcome.
Well, before I introduce our speaker of the day, Mr. Puba Mahalingam, let me sort of dwell a little bit about this subject. Some of our participants may be thinking as to why did we choose this topic for the webinar. Why do structural engineers need a professional liability insurance? Why should I participate in this webinar at all? Let me try and answer this. Of course, Mr. Puba will go in great detail and explain. But as a structural engineer, we deal with many complex issues which involve a lot of risk. We design structures which are pretty complex in nature, and we have seen also in the recent past many structural failures and the consequences. Some of us who are involved also have faced the consequences. When structures fail, the community struggles, the development stagnates, and the people around suffer. We are, as a structural engineer, we are answerable to the society and public at large. We can therefore hardly afford to make mistakes in our, in our profession. So, because of the nature of our work, we have multiple opportunities to make mistakes, to make errors while working on a project, because most of the projects in India now are on a very fast track. Infrastructure growth is so much that we are not able to cope up with the requirement, with the demands. So in the event there is a mistake, there are omissions from the consultants, there will be lawsuit by the client, and we will have to defend our work, and maybe we will be liable for a very large sum of money as compensation in case we are found to be negligent. So professional liability insurance provides engineers with the protection against these kind of damages and legal fees. It is necessary for structural engineers, at least in order to attain some peace of mind and some sense of security when you are performing your professional services with confidence. This is just a safeguard of our business from litigation cost incurred against errors or omissions or negligence and the claims. The kind of claims can be of varied nature, and there are many issues which I think our speaker will deal with. One thing I just wanted to highlight is that these concerns for the professional liability insurance is not yet very widespread in India, unfortunately. There are a lot of ignorance, not only amongst the consultants and the structural engineers, but also amongst the clients and the contractors. There is a lack of awareness, and because of which many people think that if the client is asking for an insurance, they are putting some kind of a penalty on us, whereas it is in the interest of the consultants themselves to cover themselves up for such negligence or errors, which is quite possible. And there are many other reasons also for this slow-paced growth of insurance, professional liability insurance in India. Other than the ignorance among the professionals, there are problems of cultural distaste in general for suing. Generally, we don't move the code so easily in India. The codes takes a long time, and generally there is a talk about some kind of an ex gratia compensation in case of some failures, and there are many other reasons which we will deal with as we move on the webinar. However, I can just tell you that the scenario is fast changing. Liability insurance is becoming a much talked about subject these days. In many of my projects recently, we have been asked by the client to take insurances, and in many cases they are not even, many consultants are on their own taking insurances, whether the client is asking them or not. So it is time for us as a fraternity to have a webinar where we can freely ask questions, our doubts can be made clear. We have an expert in the field, Mr. Puba Mahalingam, who is a regional risk consultant from Singapore, and he has joined us today as a speaker. So let me now talk a little bit about Mr. Puba. Let me introduce him as a speaker of the day. Mr. Puba Mahalingam has over 3 decades of practical experience in risk insurance. He is a professional engineer based in Singapore and specializes in the insurance space with special focus on construction, property insurance, and risk management aspects. Besides training, he also undertakes property risk surveys and provides consultancy services to various insurance-related clients in Singapore and also in other regions such as Asia, Middle East, Africa. Without further ado, let me sincerely thank you all participants for taking time out and being here today. I would request all of you to please put your questions in the Q&A and not in the chat box. And I also take this opportunity to thank once again Mr. Puba Mahalingam to agree to spare his valuable time with us today. And over to you, Mr. Puba.
Yeah, thank you. Thank you, Mr. Alok, for the kind introduction. Thank you to the Indian Association of Structural Engineers, Mr. Manoj Mittal and Mr. Alok Bomik for coordinating and allowing me this time to share with you, your members and guests, something about the subject of professional indemnity insurance. So allow me now to share screen and run through the material. Mr. Alok, can you see my slide?
Yes.
Yes, okay. So if it's okay, then I will start the program by explaining that, yeah, today is 23rd of April. I'm here to do this short 1-hour session. I will run through the slides and share with you all a little bit about professional indemnity insurance in project development and how does it cover structural engineers' work and duty. So I'm from Talent Asia Training and Consulting. We are based in Singapore, but we provide our services to Asia, Middle East, and Africa as well. So good evening. Welcome once again, members and guests from the IASE. And also this is a Talent Asia partnership with the Indian Association of Structural Engineers. So reminder, this is an interactive session, so I'm happy to take questions. So please type in your questions in the Q&A section, and Mr. Alok will then disturb me from time to time with some relevant points, then I can address it. Instead of keeping it all to the end, I can also take questions at the end, but I'm happy to answer questions that Mr. Alok will read out to me from time to time. Is that okay, Mr. Alok? Yeah.
Yeah, perfect, perfect.
Thank you. So meanwhile, take some notes and feel free to ask questions as we go along. Okay, so this was a face-to-face training. Now we are resumed in both Malaysia and Singapore. We are resuming our face-to-face training, but we have to practice some amount of control in terms of social distancing and wearing the mask So this was last week in Kuala Lumpur, some training. This was an online training that I did the week before. Online training is quite popular as well. So the topic for today, we're going to cover on the professional indemnity insurance, a sort of an overview. We're going to cover some overview points. Then we will look at the PI coverage, the policy schedule. We look at some exclusion. We'll also compare this with the CAR policy. Now, some of you may be wondering, what is CAR policy? What is PI? PI is professional indemnity insurance, normally taken by consulting engineers, while CAR policy is taken up by contractors, the builders, the subcontractors, the suppliers. They may want to take the CAR policy, construction all risk policy. So there are two distinct topics. I'll touch a bit on the CAR policy later, but today's focus is going to be on the PI policy. I will also finish up with some examples to bring you all to understand the seriousness of the need to arrange insurances. So some of the related project insurance are PI, that's our topic today. There's also the performance bond. Now, performance bond is like a guarantee to ensure that the contractor completes his job. Then there's the subject of workman compensation, WC, which is something that workers need to have. So again, it's a responsibility of the main contractor to arrange the WC. Sometimes subcontractors can also arrange the WC for their respective scope of work. The other item is CPM, construction, plant and machinery insurance. These are to cover specific machinery at project sites. For example, tower crane, concrete mixer, maybe the batching plant, maybe the bar bending machine, and so on. Now, the CAR policy itself, the last item on this list, I just want to say that there's also some additional coverage called ALOP or DSU. Some of you may be wondering what's all this. ALOP refers to advanced loss of profit, while DSU is delay in startup. These are very specialized coverage that takes care of project delays. So if you have a large infrastructure project, for example, it's a highway with a toll collection feature in it, it's possible to buy the CAR with LOP cover, because in case of some project-related disaster that takes place, let's say it's a flooding, and the project is delayed by 6 months, so toll collection is also delayed by 6 months. So the advanced loss of profit cover will take care of the delay. The delay for 6 months is compensated under LOP. The flooding and the flood damage is taken care by the main CAR policy. So I was telling Mr. Manoj in our earlier discussion that maybe the CAR policy is something that engineers should also consider to understand better, because consulting engineers are also normally managing the contract on behalf of the client at the project site. So it's good to know a bit about the PI, a bit about the CAR, and a bit more about all the other insurance related products that are requested or required under the contract in a project. Now, there are loads of other technical insurance policies. Again, I was telling Mr. Alok and Mr. Manoj that I'm not selling insurance in this course. I don't sell products. I advise and guide engineers, insurance companies, reinsurance companies about the product. So again, I just want to share with you all, there are few technical products. For example, the CECR. CECR is the Civil Engineering Completed Risk. So a lot of the completed highways around India, for example, the owner of the highway, which is actually the private toll concession company, they would have arranged the CECR policy. So it covers against landslide, flooding, subsidence damage on the highway. It also covers impact damage. For example, if a car damages the toll plaza or damages the guardrail, it will come under CECR. Then you have other policies like machinery breakdown, MB, industrial all risk, IAR, electronic equipment insurance, boiler insurance, fire insurance. So there's a whole range of insurance products which are technical in nature. CAR stands for contractor all risk. CAR stands for contractor all risk. Okay, so just as an introduction, okay, I also want to say some of these products come with the BI or loss of profit component. What is BI? Business interruption or loss of profit. So some of these products on this list here, they come with the BI, business interruption. So due to a project, due to flooding damage on the highway, the traffic cannot travel on the highway for 6 months, the business interruption coverage will trigger, and the highway owner will be compensated by the insurance company for the BI element, business interruption. So similar with the boiler, if the boiler breaks down, there's a fire, then the loss of profit will trigger. Okay, a quick opportunity to share with you what we do at Talent Asia Training and Consulting. We do risk surveys, we do training. We also provide advisory and technical support in relation to the risk and insurance space. So if you don't mind, I just have a quick video clip to share about what we do. I'm just thinking, Mr. Alok, can you see my clip coming up?
Yes, yes.
Okay, so that's a little clip to show you what we do. And okay, I'm back to this slide. Mr. Alok, are you back? Are you seeing my main slide?
Yes, yes.
Okay, so we, as you have seen, we have done a lot of work, not only in Singapore, Malaysia, but in the region. We have done work in Sri Lanka, in the Middle East, in Africa as well, in training, risk consulting, and so on. As far as the engineering fraternity, we have done work with the Institution of Engineers Singapore, the IEM, Institution of Engineers of Malaysia, and Puja. Puja is the Brunei Engineers and Surveyors Association. So you will recognize in some of the videos just now, there were some shots with these groups of people where we shared our knowledge and technical know-how in relation to risk and insurance, specifically the products like the PI, professional indemnity, contractor all risk, and other products. Just to remind you, we are from Singapore, but currently in Kuala Lumpur. I'm actually currently on Kuala Lumpur on an assignment. And this is a photograph to show you the link bridge, the causeway bridge between Malaysia and Singapore. You can see it's always full of traffic between Malaysia and Singapore. But for the last 2 years, it was closed. This bridge was closed. And the good news is from 1st of April, the bridge was open as the borders were open. Both Malaysia, Singapore, they opened the borders and they allow us to travel. So I was one of the early birds who came across to Kuala Lumpur. I had some assignments which were pending for a long time. So I'm actually, I travel to Kuala Lumpur on assignment. So I'll be here for another 1 week to complete some of my assignments. So I'm going to jump into straight away to a case study to show you how things can go wrong for structural engineers. So this is a beam launching exercise. Actually, the beam launching was already completed. And after some time, maybe a few days after that, a few beams toppled. So I'm going to ask Mr. Alok to speculate what caused the beams to topple. Mr. Alok, you want to say something?
Yeah. I mean, this is very commonly seen also in many Indian projects. And it is
Okay.
because these girders, while they erect, they are supposed to make it laterally stable by providing some kind of a props at the end, which in many of the cases, the contractor do not take care, I mean, whatever may be the reason. And it is because of lack of lateral stability provided on the girders that these topple.
Okay. So thank you, Mr. Alok. In a lot of the insurance cases, insurance notification, the insurance company will conduct investigation. They will appoint a loss adjuster, and the role of the loss adjuster is to investigate. Of course, the authorities may also be involved. The government authorities, public works department, they will also conduct their investigation on this matter. But parallelly, the insurance loss adjuster will also conduct investigation. Sometimes they might even engage another consultant to counter-check the design calculations, the geotechnical information, and so on to establish what happened. So, Mr. Alok, in this case, what happened was, it was not a design. It was not a design or structural issue. The blame went to a subcontractor's driver. The lorry driver had come to deliver material to the project site, and he was making a U-turn. He made a U-turn in a very tight environment, and during that process, he lost control of the vehicle, and the vehicle hit one beam. And after that, a series of beams came tumbling down. So it all fell down like dominoes effect. So in this case, it was not a PI policy. It was not a professional indemnity insurance matter. It became a CAR policy matter. So the CAR policy, contractor all risk policy, will respond for this loss. But hold on, what happens is the insurance company will then go after the culprit. Who is the culprit? The lorry driver of the subcontractor's truck. So who has a motor insurance policy. So insurance, the insurance business gets a bit complicated because there's going to be recovery. As a consumer, you don't have to worry about that because the insurance company takes conduct of the matter. They will then get the lawyers to go after the motor vehicle insurance of the other truck. So these are typical scenarios. I just want to start the discussion by showing you. This one is one of them, the beams falling down. Now I have another one here. 1 death and 10 injured after collapse of uncompleted TPE PIE viaduct near the airport. So this one happened in Singapore. During the construction, they were pouring concrete. The contractor was pouring concrete when this thing happened at 4 o'clock in the morning. So in this case, the investigation, this is actually the detailed photograph of the loss. And the problem was blamed on the design. Yeah, this one went for design. And the blame went to the design of the, what do you call this component, Mr. Alok? It's called the connection between the beam and the cobble. Is it a cobble? This is the cobble bit. The cobble bit was under design. So that led to the whole thing falling down. So this
the pier cap, it's called pier cap.
The pier cap is a whole big thing, but the concern here was the little protruding, the protruding item, which was said to be too small to cater for the size of the beam that it's carrying. So this one became a big design issue, but because it was a design and build project, the contractor was also terminated by the authorities. The government authorities, in this case, terminated the contractor, and a new contractor was brought in to take up this matter. So this was very much a PI related loss, professional indemnity insurance, because the standard CAR policy, the standard CAR, the contractor all risk policy, will not cover for design. So the CAR policy will say, no, it's not our responsibilities. Then the arrow is going towards the consultant, and the consultant needs to have the PI cover, professional indemnity cover. Okay, so this is another view of the same collapse that took place. This was 4 years ago, just showing you. Okay, this one is another one. It's a newly completed housing scheme, and there was sort of damage. And actually this damage was attributed to heavy rain and flooding. So in this case, there was some dispute between two parties. The contractor blaming the consultant for the poor design, while the consultant blaming it on the act of nature, because there was a storm, there was a heavy rain, and there was flooding, and it led to this kind of road damage, and also some elements of the building, the front part was affected. So this is another classic case on whether the PI or CR policy will respond. I don't know whether Mr. Alok got any comments to when he saw this photograph.
Yeah, I mean,
any
you see, yeah, I mean, generally, when there is some kind of a natural hazard like floods or earthquake, and if there is a failure, it is quite natural for contractor or the consultant to sort of say that it is a natural thing.
Yeah.
But there needs to be a distinction, in my view, between a natural hazard and a natural disaster, because disaster is not really natural. I mean, if you cover for the natural hazard, you are supposed to cover in the design and construction the natural hazards.
Yes.
So that is not a disaster. Disaster is man-made.
Yes. Okay. So you're speaking like a lawyer, Mr. Alok. You've gone through these things. So this is just a class example just to share with you one of the issues which can be contentious, but the PI is there to protect the consultant for the design aspect. Okay, briefly, just to mention my background, Mr. Alok did mention, but this is a brief slice about my involvement in projects and insurance and risk type of work. So I've been involved in various project risks in the region. I was the president of the Insurance Law Association in Singapore, ILAS. Now, in the last 6 years, we are involved mainly as a consultant or as a risk consultant looking at project-related issues, risk surveys, and providing training. So this is something to mention. We have our own textbook as well on engineering insurance. This is published by the Malaysian Insurance Institute. So I'm the author of this publication to share with you. So these are some of the events that I did some training session in the past with CIOB, Chartered Institute of Builders. And these are some of the training that we've done: construction, professional indemnity, and so on. This was in Bangkok. This was in Jakarta. We spoke at a conference on NetCat. This is in Mauritius. We've been involved in Mauritius. This one is in Mongolia, Cambodia, Bangladesh, India. So I also spoke with another engineering insurance body before. In Africa, we spoke with the African clients. Singapore, this is Singapore. And this is a typical virtual risk survey that we do, because we can't go to Vietnam to do the survey for insurance purposes. So we do a virtual survey using the Zoom platform and WhatsApp video. Okay, so the session itself, we are looking on the PI policy. So I wanted to ask Mr. Alok to just say a few words about the need for PI policy in terms of the requirement in the Indian market. What does the legal requirements for PI policy? Mr. Alok, can you just enlighten us whether PI policies are required and made compulsory by law, or is it depends on project to project? Mr. Alok?
Yeah, thank you, Mr. Kuba. First of all, let me at the outset admit that I myself do not have much knowledge about the liability insurances. But one thing I can tell you, that firstly, it is not mandatory. In some projects, in some particular clients may, enlightened clients may make it mandatory. I have faced 2-3 such projects where it is made mandatory. But in many projects, it is not made mandatory for the consultant to take the PI. And also I have faced situation where the client is equally ignorant about the liability insurance, and once the contract is drawn, much later when the drawings are issued, they ask the consultant to sign affidavits, stating that your design should be fit for purpose, etc., which at that time becomes a conflict because the consultants, at least the enlightened consultants, do not agree to such terms in the middle of a contract.
No,
But
Alok,
yeah,
I think this is not mandatory as per the law, but
yeah,
but clients can make it mandatory according to the contract conditions. Sometimes they put a condition in the contract, then it becomes a mandatory. But it is a project specific or it is a client specific. Or sometimes consultants may take it in their own interest, even though clients may not ask for that. So yes, as per the law, it is not mandatory.
thank you, Manoj.
Yeah, thanks, gentlemen, for your clarification. So the subject itself is technical in nature with the insurance component put in. So the idea of this course, this short 1 hour session, is to enlighten the participants a little bit about the insurance terms, what you should declare, and I will try and cover that in relation to the policy. So this is a completed highway, which is in Singapore. It's a completed highway. Everything is nice and beautiful. So if something happens, who's going to be blamed? Who's going to be blamed? Can you blame the contractor? Can you blame the consultant? Can you blame the car owner? So there are many parties to blame. So again, for insurance purposes, we will do the investigation. Insurance company will do the investigation to find out who is the culprit. Contractor already left the site. Mr. Alok, the contractor already finished his obligation. He left the site. You can't hold him unless it happened during the maintenance period, during the defects liability period. Yeah, you can catch him for that. But beyond that, if there are grounds, the consulting engineer can be blamed because it was a design that was drawn up by the consulting engineer. So the consulting engineer is responsible for this, and it could go back to him. In this example, which I have shared here, is actually a water pipe that gave way. The water pipe belongs to a private utility company. Their pipe gave way, resulting in the collapse of the ground embankment, and the road was disrupted. The road traffic was disrupted due to this pipe burst. So it was not really a design matter, but I'm just sharing with everybody things that can go wrong. So like in this case, which I showed you just now, it was a design problem. This was in Singapore. The bridge under construction, they were pouring concrete, it collapsed. So the blame was on the design of the pile cap, the beam, the cross beam design was blamed for the shortcoming. This is another one I managed to pull out from the newspaper. This happened in Malaysia. This was a few years ago, where the Malaysian works minister, Sami Velu, some of you may have remembered him from 20 years ago, a very popular gentleman in politics. And he said that the cracks on the bridge were due to defective design. By virtue of that, that has an implication on insurance policy and coverage and so on. So there are a lot of issues to go through when it comes to design. When the blame goes to design, then the consulting engineer is blamed. Okay, this one is another one, embankment failure. It's a road construction project. And what happened?
Mr. Puba, can I interject in between?
Yeah, sure.
Okay. You see, you said that if there is a problem of design, then the designer is responsible.
Yes.
But what if the design is it's a design and build contract where the designer is appointed by the contractor, in which case, and the client has got the contract directly only with the contractor.
Yeah.
In which case, who is to be blamed? Is the contractor not responsible?
The contractor will have contract obligations with the client, yes, but he in turn would have a back-to-back arrangement with a consultant. So hopefully the back-to-back arrangement with the consultant, they have taken up a PI policy. So that's when everybody will scramble to look at the contract and look at the obligations of the contract. What does the contract say? And what are the requirements? So insurance is one of those elements in that protection. There should be a PI policy because the CAR policy may not respond for this loss because it's a design problem. So that's why it's very important for any project. You need to ensure that the PI policy is there, the CAR policy is there, and the contract wordings be tight as well. You've got to make sure it's all in order. Don't just sign the agreement and get on with the job, because when something goes wrong, everybody is going to start pointing the finger. The blame game will go on, and then we're going to have a problem. Is that all?
Yeah, thank you.
So it all depends. The contract, it depends on the contract, depends on the insurance coverage, and also the investigation. Again, on investigation, it varies, because you might say that this is due to a material problem, but the consulting engineer appointed by the by the loss adjuster or the insurance company may say something else. Sometimes you can have differing opinion, and this differing opinion has an effect on the insurance claim, to pay or not to pay the claim. And these things can be disputed. It can go to arbitration. It can even go to legal disputes in the courts. All right. So in this case, this embankment failure loss, we are asking whether the CR policy will pay. If the CR doesn't pay, will the client pay? Because the client, being a highway company, they may have an issue as well, because they have to pay 1 million or 2 million US to make good the damage to the embankment. So this is also a serious matter. They might also ask to rectify other sections of the highway which were not damaged. So this can get quite serious, and then the consultant could be blamed. And that's why the consultant need to have the professional indemnity insurance. The professional indemnity insurance is there to protect the consultant against such claims. And these claims can come from the project owner. It can also come from a third party. Okay. CR policy, you need to have a damage. For PI, you don't need to have a damage. It covers for any of the things going wrong or about to go wrong. There should be some coverage for that. I will say more about the operative clause of the PI policy in a while. But before that, I just want to mention a little bit about the principles of insurance. Now, these are 6 important principles of insurance. The first one is utmost good faith. When you buy insurance, you got to declare that you are a smoker or non-smoker. If you're buying life insurance, you got to declare. You must also mention your age. So when it comes to PI policy, you got to declare that you're professional, that your consulting engineering firm, you have 10 engineers and you got 3 directors. And then the values of your project, you're doing mainly building jobs or highway jobs, you have to declare. So all these must be declared. This is called utmost good faith. Insurable interests, you have to declare your interest in the project. As the consultant, you have that sort of interest. You're not the owner, you are just a project consultant, so you're involved in the design aspects. Proximate cost, I try to give you some idea about proximate cost, like design problem, flooding problem, embankment failure, landslide. So investigation is very important. For insurance claim, investigation is very important. So a lot of times the loss adjuster will do the investigation. Sometimes they'll engage another consultant to investigate. Sometimes they might even appoint a forensic scientist to investigate. Now the next point is subrogation. Subrogation is recovery, going after the culprit. So as I tried to give you an example just now, in the case of the CR policy, if it's not paying, then the client will get involved, and there will be a recovery action against the consultant. So this gets very complicated with that kind of recovery. Then the consultant has got no protection if he doesn't have the PI. Indemnity is to put him back to where he was, because prior to the loss, he's got this bottle, a 5-year-old bottle. So if there's a damage, you get back a 5-year-old bottle. So basically, it's to put you back to where you were. And remember, insurance, you can't make profit. The purpose of insurance is not for profit. If you want to make profit, you better buy a lottery ticket. Lottery ticket is different. But this insurance is to put you back to where you were. The last one is contribution. Contribution is sharing. When you have more than one, if you have more than one policy, then you will share and cover the loss. Perhaps there's 2 consultants working on a job. Maybe the main consult, the lead consultant, and you have a sub-consultant. So there's a design problem. Both are have been involved in the job. So there's going to be contribution here. So this is the principles of insurance. The principles are insurance are applicable for the overall operation of all policies, whether it's CR or PI policy, it applies. Now, who buys PI cover? Doctors, lawyers, accountants also buy. So consulting engineers also should buy. It's good protection to have. Now, what are the roles of the professionals? They are doing the design, they're doing the calculation, they're doing the supervision. So for that purpose, the PI policy will cover their professional duties. That is the purpose of the PI. So it covers for professional negligence of the consultant or architect. For example, errors in design miscalculation, drawing dimension, he gave the wrong dimensions, or misrepresentation. So all these aspects are covered under the PI policy. It's not a straightforward matter. The loss adjuster will ask a lot of questions. You have to patiently answer the questions. Sometimes another consultant may be invited to investigate, and lawyers will also step in to be involved in such disputes involving professional indemnity insurance. Okay, PI form. Now you need to fill up a proposal form. When you want to buy PI policy, you need to fill up a proposal form. Now there are two options of PI policy. One is an annual PI. Annual PI, the consulting engineer buys every year from January to December. You renew every year. Or you could buy a SPPI. SPPI is a single project PI. So single project PI is normally arranged for large project. For example, during the Olympics, there's a development of a few buildings by the Olympic Council of India, for example. So they build 3 big stadiums, 2 smaller stadiums, 1 swimming pool under one body, and many consultants are involved. So the client, which is Olympic Council of India, will ask to buy a SPPI, and the SPPI will cover all the consultants. So in a way, it's more effective and cheaper to procure a SPPI because it covers many building projects within one large project. So that's called SPPI.
So are you are you trying to say that sometime owner takes the this kind of a policy for the consultants?
Yes. Owner
and consultants pay the premium for that.
No. When the SPPI is arranged, the owner already take care of that payment. He already arranged it. He already arranged it, but he has to declare to the insurance company that there are a total of 14 consultants involved. There's the M&E consultant, there's a structural consultant, they also have a landscape consultant and traffic consultant, a total of 14 consultants in the job. So the entire premium is taken care by the owner. Yes, owner. So for a big job. But annual PI, then it's up to the individual consultants to buy. And it's on a case-to-case basis. There'll be premium charge and so on. The second, thanks Manoj for asking. The other point is retroactive cover. Retroactive cover is in a way backdating of the cover. This is perfectly legal. There's nothing illegal about it, because in other disciplines of work, when you talk about backdating, it's not proper and not acceptable. But for this product, PI, for PI insurance, it's quite normal to have retroactive cover. Reason being, Mr. Alok, your business has been running for 15 years. Your first design was done in the year 2008. So because of that, you need to have retroactive cover. So the policy, although you buy the policy this year, but it has retroactive from 1st January 2008. Any design done for the last 15 years is covered by virtue of the retroactive cover. So that is an option that you have to include in such a PI cover, because your company is not just established this year. You've been running operations for 15 years. So important for you to buy the retroactive cover, because some design failure may happen at the 14th year or 15th year. So that's why you need to have retroactive cover. So the period is, it covers the entire period during construction and post-construction as well. So in the proposal form, they'll ask you all these questions like typical fee charge and so on. This is a typical proposal form that you need to fill up. for PI policy, like the detail of the project, who to contact, and so on. But I don't want to spend too much time. So finally, you'll be given a policy jacket and a schedule. Jacket is a standard wording. Schedule is related to your coverage. Yours is a 1-year coverage, and it covers your particular firm, and your company address is given, and the date of cover is maybe 1st of April 2022 to 31st of March 2023. It's 1-year cover. It can be January to December, or it can be April to March. So in the policy schedule, it will tell you all this information, the name and the limit of cover and so on. So for policy period, for SPPI, it could be longer, it'll be 5 years. From the time the design is planned, the project is planned, the design phase, the construction phase, and maybe 1 more year. So the SPPI will run for a longer period. All right. So this is the sort of items in the insured. They will also mention the excess. Excess is the amount to be paid by yourself. In case of a claim, maybe 50,000 US dollars got to be borne by yourself. Anything beyond 50,000 is taken care by the insurance company. Professional services, he will say that structural engineering services for high-rise buildings and factories. So that's the professional services. Or you may be a geotechnical engineer providing ground treatment works in India and overseas. So where is your scope of services, whether it's India, overseas, you got to tell the underwriter. Remember, utmost good faith. You have to declare the truthful information. Retroactive date, I've already told you, premium, governing law. So these are things that will be mentioned in the schedule. So finally, the document is signed by the insurance company. So that's the policy. Now, these are some of the typical exclusions. Cost overrun. The policy will not pay for cost overrun. If the project, you have a problem, and instead of a 2.5 million US project, it ends up for 3 million because of some design calculation or because of some additional work, policy will not pay. Number 2, any issues about insurance, failure to advise the client is not going to be covered. Day-to-day site administration, design change will not be covered. Last one, fraud also will not be covered. So these are some typical exclusions in the policy. There could be more in your Indian market. So you have to study the policy. Now, these are typical clauses: emergency defense costs, mitigation rectification. Pollution is another point to consider. Sometimes you got a pollution issue and somebody takes action. So you need to be protected for the pollution aspect. Lifetime runoff for retired employees. Okay, so Mr. Alok, you have your firm, and finally you're retiring after when you reach age of 65, but you're still concerned about your design that you did 20 years ago when you were the director in charge. So this clause will take care of your liability for rest of your life by virtue of the lifetime runoff for retired employees. So these are typical clauses. There's also the other insurance clause, and this covers when there are more than 2 consultants involved. Say one is from consultant A, one from consultant B. So both have to contribute to the loss. Then, according to this policy, both insurance companies will come together to share the loss. Okay, so these are some of the typical design issues like under design of column, foundation design, miscalculation, depth of tank. I just got a few examples here, design related issues. So such design related issues will be covered under the policy. So in the event the client pursues a claim against a consultant architect, they will cover for financial, they will take care of the defense costs and litigation as well. So that's the purpose of the insurance policy. So there's a financial claim coming from the other side. So for mixed development, you need to cover PI for all elements of work, earthworks, the structural design, project management. The whole list is covered under the PI. Now, why you need to get a PI? Because clients are getting more cost conscious. Contractors are also getting technically qualified. You have big contractors like in India. You got L&T. L&T have their own technical people. They have their legal team. They will dispute on designs as well. So on your part, you need to be protected. You need to also enhance your team members and also have the PI coverage to protect yourself. Contractor is no longer in the bottom of the food chain, is no longer true. I don't know, Mr. Alok, what is the situation in India? Are contractors in the bottom of the food chain?
In construction industry, yes, I would say.
No, but then
They are taking the maximum risk.
Yes, yes. But then they will pass it on to subcontractors as well. So the chain continues.
Yeah.
Okay.
So when you say contractor, I cover everything.
Yeah.
Subcontractors as well.
Sure, sure. Next one, value engineering expected from consultants. Consultants are expected to advise client, avoid all these design problems and so on. Okay. Site incidents may lead to project delays. Consultant may be held liable. Even if the CR policy pays, recovery against consultant can be pursued because the CR insurance company will go after the consultant. So you need to be protected. You need to have a PI policy. Next one, so society getting more litigious. They also, everybody is blaming everybody else for this and that. Another professional example, doctors required to arrange PI. I'm not sure about India, but in Singapore, doctors need to have minimum PI. Lawyers also need to have minimum PI. Mr. Alok, are you aware of anything of the Indian market?
I think yes, the doctors need to take PI.
PI,
they have
yeah.
to cover themselves. But
Yeah.
I have a question here.
Yeah, sure.
Mr. Puba, the engineers, are they supposed to take PI individually or if they only the organization? If you are working for an organization, are you also expected to cover yourself as an individual?
No, individuals don't take policies. It's normally the corporate. The corporate buys the PI. So when the corporate buys the PI, they have to declare that they have 15 engineers and 3 of them are directors with 20 years experience. And they have associate consultants as well. And their team is like this and their business turnover is so much. So you have to declare in the book.
But suppose there is a failure and, when it comes to investigation, there may be individual in that organization who has committed the error. So who is liable? I mean, other than, of course, the organization will be liable. But is that individual not liable for the failure?
Yeah, of course, the individual, the engineer who signed the drawing, the director of the firm, he has to take the hit. But the company will protect, the insurance policy will protect the company. But like in Singapore, the case of the collapse in Changi, the consulting engineer had to go to jail. So going to jail, you can't run away, you can't hide behind the insurance policy. But the financial implication, the fine imposed by the authorities is taken care by the PI. But the individual has to go to jail, you can't help that because they found him guilty of not being responsible in the design.
Thank you.
Okay, I just want to remind you that in the CAR policy, it excludes faulty design. In the standard policy, CR special exclusion, faulty design excluded. That's why I'm reminding everybody, you have to protect yourself by PI policy. If you don't have that, you are exposed. So please think about that. So this is an example that I have about structure. The column gives way and because of some design problem, then the blame is going to go for the design because the CAR policy won't pay. And a few more other cases, RC tank failed due to inadequate reinforcement, height increase for cooling water structure, slope protection failure case, LRT project consultant was blamed for height clearance issue, bridge over crossing beams fell like dominoes. So these are some cases that I have. Okay, this is the water tank that cracked up quite badly because of design problem. They increased the height, but the reinforcement was not adequately looked at. This is a slope failure, also blame on design. This happened in Kuala Lumpur. This was a height clearance issue. Height clearance to allow the tanker to pass. So the blame went to the consultant because he never set the correct height as specified by the principal. So it was not a construction problem because the contractor followed the drawings set up by the consultant. The height clearance was the issue. This one is another case where the beams fell down and the blame went to the consultant. This one is another one. where the beams all fell down onto the railway track. Lucky the train just passed and the train was not hit. It just damaged the railway track and a few beams fell down. So this is another case where it was a blame going to the consulting engineer. This one is some flyover construction method save. This was in Malaysia. This is the one where the Samuelu was involved and he said design flaws the cause. So because of that, the blame went to the consulting engineers. This one, Helcro was involved. Helcro was involved in the investigation and put up the report, and then Samuelu said that this and that in the parliament and so on. So this is a temporary design. Temporary design is also a responsibility of the consultant if they put up the design. So that is also covered under this PI policy. So the point is, you need to consider PI policy. You need to procure PI policy to cover your business operations. That's the point. And some examples to show you this cantilever structure collapse. Mr. Alok, do you know this one?
Is it? This seems to be in India.
Yes, this is an India case.
Yeah, Jamrudpur. Is it Jamrudpur collapse?
I'm not sure. Somebody may.
Yeah, this is in Delhi.
Yeah, this one is in Kuala Lumpur. It's a bridge across a shopping area, a steel frame structure. It's a curved bridge, and it collapsed. And due to the collapse, it was also a CAR policy and PI policy was triggered. After the collapse, they changed the design from a curved bridge. They went to a straight bridge, straight steel bridge. So, you know, curved bridge, there are different design consideration to consider, but somebody, I think, didn't do that the correct way. And the things collapsed. One worker was killed because he was having his lunch underneath the bridge under construction. So this is a classic PI issue. This one is another one, some steel bars, while pouring concrete, everything collapsed. This one is another drama, but this is more a construction issue. Flooding of the road due to the contractor's work. He blocked the drains for something else and the whole highway was flooded. This one is another highway issue where there was a landslide and the road was blocked off. And this one, the photo tells 1,000 words. The piling rig fell on a passing car. Now, this is very much a third-party property claim under the CAR policy. So normally, when you're going around nearby construction sites, be careful. These kind of things can happen. So the driver and the passenger were killed. Nothing to talk about. Total loss. Okay, almost the end. And thanks for listening. I welcome questions or points from the audience. Through Mr. Alok. Yeah, thank you.
Thank you very much, Mr. Puba. Excellent presentation. Very, very enlightening.
Thank you.
And I see a lot many questions in the Q&A box, and I would request all the participants to put more questions now. Meanwhile, let me start with the questions which we have already received. There is a question.
Alok, before you take, I want to ask one question. Yeah. What is how much coverage a professional engineer should take for PI, and what will the typical premium? Can you give some idea about that?
Okay. This value, Manoj, is not like CR policy. CR policy, you follow the project contract value. So if your project is 25.5 million, CAR policy, you buy for 25.5 million. But when it comes to the PI, normally it's a smaller figure. We might propose something like 1 million or 2 million US for that annual PI. You don't buy the full value, because if you want to buy 100 million PI, the premium is going to be crazy. It's not viable for you to pay. So it's going to be a smaller figure, maybe in the order of 1 million, 2 million US. As a start, or maybe you have a small practice, 1-man, 2-man show, maybe you buy 500,000 exposure. Also depends on what your client says. Maybe your client, which is the utility company of India, they ask you to buy PI for 5 million because you're involved in transmission tower design and project implementation. So they ask you for 5 million US. So that is the order, 1 million to 5 million, Manoj. And in terms of premium, I can say for 1 million cover, maybe you'll pay something like 20,000 US dollars, 20 to 25 or 30,000. Again, depends on your company credentials, experience, the team that you have. If you are a new young team, maybe the underwriter may charge, the insurance company may charge higher. But what happens in a lot of in countries like in Malaysia or Singapore, the association pulls the people together. Maybe this is something, Manoj, you can take up as a association project where you can talk to the insurance company and you round up all your members and you offer a scheme to your members, insurance coverage, and have it as a pool coverage for all members of the Indian Association of Structural Engineers. So that way, the insurance company is also happy to deal with you because you are already filtering and bringing all the members together, and they're providing you the best coverage. So they give you a deal and say, for the 1 million cover, we don't charge you 20,000 US, we only charge you 15,000 US if you are a standard company. So that could be a way to consider an association initiative, because I know the IES in Singapore has that. The Institution of Engineers in Malaysia also have a scheme. They tie up with the insurance company to provide the PI cover for engineers. Because if the engineer goes himself, difficult for him to procure the coverage. So please think about that. And I hope that my answer on the values give you an idea.
Yeah. Okay. Thank you.
Thank you.
Okay, Manoj, I think we can take up questions from the panelists.
Yes. Okay.
And also I have my own questions, but I would like to first take up the questions which are there in the Q&A box.
Okay.
So the first question is from Mr. Paul Emily Durand, who says, isn't there a dispute, the notion of force majeure here? I think he might be referring to some specific slide, because from the question, I'm not sure what it is.
No, I think Alok, he brought this up when we spoke about the flood damage scenario.
Okay.
So the flood damage and the road was damaged. So I think force majeure is an issue that comes up when you have a contract. When you have a contract, you know, the typical construction contract, there is some limitation or clarification on force majeure. But from the insurance point of view, doesn't matter whether CR policy or PI, we are looking at different aspects. We don't go into the notion of force majeure. The contract administration is different. The operation of PI policy or the CR policy is different. Hello?
Thank you. Yeah. So next question is from Mr. Rajiv Ahuja. He is asking, what happens when a consultancy agreement does not include a limit of liability clause and there is no PI insurance taken by the consultant? In the event of failure of structure, what worst can happen, and how do courts decide if a claim is filed against the design consultant?
Yeah, so that normally the limit of liability is specified in the contract or the client. The client, let's say, is a utility company from India. They specify for the design consultant to buy a PI for 2 million. So they do that. That's good to have a limit. But if there's no PI, then the authorities take action and they go to court and they declare that due to this collapse, the loss is 10 million US. There's nothing to stop the authorities to pursue whatever they want to pursue. So the design consultant is exposed. He doesn't have protection.
He's not covered. He doesn't have the coverage.
Yeah. So he can be sued for all his pants and clothes and everything, his own property and so on. And also depends whether he's a private limited company or it's a sole proprietorship. If it's sole proprietorship, then the claim can go against his personal belongings as well. Then it gets very complicated, Alok, the design, the responsibility and so on.
Okay,
yeah.
So there is a addendum to his question. Further, even if professional liability insurance is taken by consultant and the contractor files a case against the consultant for a very large amount, what happens? I mean, he's talking of a case where the consultant is appointed by the contractor.
Yeah, then it goes into a legal dispute, but the two parties will be fighting with each other in court. Then there's no PI policy, so each party has to get their own lawyer to pursue the matter. There's no I can't guess what's going to happen. It will be long drawn battle in the courts. You know, there's no insurance coverage there. Unless Manoj has got some comment. Manoj?
No, I think you are right.
Yeah. Let's get
Okay.
on. Alok.
Okay, so the next question is from Mr. Chandrasekhar Kure. He's asking, sir, if the proof checking is done by the third party, who is responsible?
Yeah,
I think
so,
you mentioned about the shared responsibility.
yeah, there could be a sharing of responsibility because both of them have responsibility, because the original design consultant did the calculations. The checking engineer also did some checking, but they let it pass through and the whole building collapsed. So both are liable. So there's going to be some sharing of responsibility. Yeah.
Okay, next question from Mr. Nishad Kulkarni. Does the
Alok, just a minute. This sharing of the responsibility, you are saying from the legal point of view or from insurance point of view?
Insurance point of view, but subject, of course, it is also based on the legal point of view. So at some point we have to say 60-40 or 40-50, 40-40 or whatever. Somebody's got to make a judgment call. Sometimes you're not so comfortable with it, so we have to dispute, go to court to work out the percentage of responsibilities.
No, but how you decide this 40-60, 60-40? It is written in the contract, or it is written somewhere in the policy, or how you are saying this kind of a responsibility sharing?
It is based on the assessment by the loss adjuster. Maybe there's a lawyer involved, and looking at the work involved, the majority of the work was put together by the original design consultant. So his input may be 70%. The checking engineer, 30%. So they decided to share 70-30.
So it means you are saying that insurance company may pay 70% to the consultant.
No, to the claimant.
To the claim.
Yes.
To the claimant.
Yes.
Okay.
But these things, because the other side may not agree, the other side may dispute their liability. They will say that no, we are only the checking engineer, we are not liable, and we have our own agreement here that we cannot be liable. So these things will happen. You know,
ultimately everything has to be governed by the contract. What kind of a agreement is there with the proof consultant with the consultant?
Yes.
Ultimately, that will be the governing factor.
Yeah.
So Manoj, what I understand in this is that unless there is a clarity about this, proportion of responsibility, etc., in the contract, then it is left to the judgment of the person who is resolved, who is a lawyer.
Yeah.
It is his perception.
Yes.
And then of course the individual claimant can question that. Yeah. So ultimately it will be resolved based on the judgment.
Yeah.
So it is. I mean, it is not necessary that the same solution will come out in two different cases, which may be similar.
Yes, correct. Yes. Yeah.
Okay. Then there is a question by Mr. Paul Emily Durand. For cost overruns, if you have a duty to stay within some quantities.
Sorry, Alok, you missed something, Alok.
Okay. I missed one, Mr. Dr. Sushil Dhawan. I'm sorry. Dr. Sushil Dhawan is our governing council member. How could I miss? So he is asking, one in professional indemnity in the context on the event of damage or failure, what type of damage claim the department can ask on the event no liability clause? In case, I mean, what I understand is in case there is no liability clause, how the department can ask how to rule is not applicable against any statute in the Contract Act. I don't know, Mr. Puba, if you have understood this
Alok,
question, you can answer.
we asked Dr. Dhawan to talk to me privately. I can't take
Yeah,
that.
okay,
It's too
okay.
complex. But his second
And the
question.
second one is, what is SPPI? I think you
Yeah,
have already replied
SPPI
that it is.
Oh, that is already
project
clarified, yeah.
professional-
No, it's single project PI. Single project PI.
Single project PI, yeah.
Yes.
I think you have explained that.
Yes.
clearly. So we come back to the question from Mr. Durand. For cost overruns, if you have a duty to stay within some quantities that permitted the contractor in a design and build job, can the PI be used for a claim if you exceed the quantities developed at tender?
Yeah. I think this is exclusion. It's an exclusion in the policy for
That you mentioned.
Contract value increase. They will not cover for that.
Now, another question from Dr. Sushil Dhawan. Please explain about the value engineering. Whilst it is applicability in the construction project.
No, I think it's a very generic question. I think value engineering is a well accepted.
No, let him answer. Let Mr. Puma answer.
Yeah, no, it's a accepted practice in industry. The client asks them to give value engineering input, and then there could be some dispute about that particular cost-cutting measures, and then the consulting engineer could be blamed for those effects, those kind of things. So I don't want to say too much.
Okay, so there is a question from Mr. Girish Wadhwa. How many insurance companies in India are active in PI? Few years back, I could not get an info on PI in India. Manoj, do you have any idea?
No, I don't have much idea.
No,
I also don't have, but there are few.
There are about 30, 40 insurance companies. As I said, the big ones are like, Bajaj, Allianz, and there are many companies. AIG,
Yeah,
AIG,
IFCO Tokyo,
Tata,
IFCO
Tokyo, because all these are merged with overseas company like Tokyo is Tokyo Marine of Japan. AIG is American. They are tied up with Tata. Tata, is your big Indian company. So there are many insurance companies. If anybody needs information, drop me an email. I will connect you with the insurance officers or brokers. There are also brokers that you may want to approach to arrange on insurance. But I don't know whether your association, Mr. President, do you want to consider arranging policies?
We will. It's a good idea. I think we will explore that. We can explore that.
Yeah, thank you.
Okay, the next question from Mr. Moina Ghoshal. I think you have already clarified in your presentation to discuss pros and cons of PI versus CAR policies. I think this you have already discussed in great detail. The next question, Mr. Pradeep Panchal. What is the cost of PI per million cost of work?
Yeah, so Pradeep, to answer Pradeep's question, it is not per cost of work. PI doesn't follow the contract value. PI follows the limit of liability. I told Mr. Manoj just now, we are asking to buy 1 million US or 2 million US based on your exposure in that project, because it's unlikely that the whole building will fall down. Maybe there's some small elements here and there due to your steel bar detailing issue. Maybe there's some small problem, maximum up to 1 million US. So it's not per million of cost of work. CR is worked up per million cost of work.
So, Mr. Puba, I have a question to ask.
Yeah.
If you have a structure which is say costing X amount,
yes,
the consultant who is engaged is getting only maybe 1% of X, 0.01 X. Now, how much he should be covered? Is there any limit? I mean, his liability, is it restricted to the maximum his fees, or it can be even more than his fees?
Okay, so that depends on your agreement with the client. When you draw up your consultancy agreement, do you limit your exposure to that 0.1% of the X value? Do you do that?
Yeah, normally in some projects, yes, but in some projects it is not so explicitly written in the contract agreement.
Yeah, so irrespective, because you have 10 projects running at any one time, but you want to have a PI cover for 1 million US, irrespective of your jobs. You got apartment job, you got office block jobs. So I'm saying you just buy 1 million cover. Don't worry about the individual jobs, because we are talking about an annual PI.
Yeah, but when you are taking an SPPI, then
Different.
would you limit yourself to a fixed percentage of the fee
Okay.
or?
Yeah, so SPPI gets different. Then the client sees the exposure. The client thinks that after looking at the overall project of 100 million US, he buys a SPPI value for 5 million. That's the client's call. Yes. Okay. There's a lot of subjectivity here. In fact, the next question from Mukund Jail, he's asking about premium amount. So premium depends on the company's background, their expertise, the years in business, their track record. Maybe they had a claim last year, they were in the newspapers because they were involved in the design of a bridge that collapsed. Then they'll be in big trouble. The premium computation is different than compared to a good guy like Mr. Alok, who's got a clean record over the last 20 years. So it all depends. It's very subjective. And you can go to a second insurance company and they might give you a cheaper rate. So it's very much willing buyer, willing seller sort of thing. You can shop around. But when you shop around, you must be also aware of the clauses because different companies will give different coverage. So you might think that it's good, but Apple and Orange are different. Apple is good with vitamin C. Orange is good with vitamin something else. So I don't know. You have to compare. And those kind of comparison, you may want to talk to somebody like me who will be able to look at the policy and give some commentary in terms of coverage, appropriateness, and so on. Hello?
Okay, so next I'm skipping one or two questions, which I think is already answered. So I will come to this question from an anonymous attendee. What kind of insurance is generally used in UK construction insurance? Some consultants supporting offshore works. In this case, do we need to take two insurance policies, one for offshore and one for onshore?
Okay, so UK similar. Whatever I'm talking is very much following the UK because we are all Singapore, Malaysia, India, Hong Kong. We are all UK colonies. We are part of the Commonwealth. We follow similar UK practice. But what I want to tell you is, once you talk about offshore work, once it's offshore, then the risk is higher. So different terms come in. It's not going to be the normal terms. So for example, Alok, if you're doing an offshore fabrication design of a oil drill platform, the premium is different. It's a high risk. So consideration is different. So we better ask Anonymous to talk to us separately. Difficult to talk. Difficult answer.
Okay, thank you. So there is a question from Mr. Pradeep Panchal. How to justify premium charged by insurance company in case of PI? How do you, they will go through, you need to fill up the proposal form, then they will look at it and give some points. And it also depends on a deductible. They might give you a premium of 20,000 US dollars, but they might say the excess clause is $50,000. So any claims up to 50,000, you have to bear from your own pocket. So it's there's a lot of subjectivity there. It's not fixed price. This one you can buy for 5 US, no problem. It's fixed. But insurance is very subjective. There's a lot of subjectivity there. Okay. So there is a question from Mr. Ghoshal. How does FIDIC conditions help or hinder CAR versus PI?
Okay, FIDIC is talking about the administration of the contract, and normally FIDIC is only talking about the contractor's participation. Contractor need to buy CAR policy. That's it. They don't talk about PI. But I think the silver book, when it comes to that design element, FIDIC has got a few colors. I think it's a silver book talking about design and build. There they say something about PI. But Alok, I can't remember the details, Alok. I have to check on that.
Now, Mr. Puba, I have a question.
Sure.
These two terms are often coming in our contracts. One is fit for purpose and one is reasonable care. Can you enlighten as to what is the difference?
No, these are coming in your contract. So that's you have to tell me the definition. I am coming with my insurance expertise. So
see, from the consideration of insurance, PLI, if I have to take a professional liability insurance and my contract, I'm talking about an SPPI. In my contract, it is mentioned that the design has to be fit for purpose, or a contract which says that my design has to is not necessary to be a fit for purpose, but you got to have reasonable care and skill in the contract. So will the PLI amount, premium amount, same for both, or will it be different?
No, it will be different.
So what you have to do is you have to furnish your contract requirements to the insurance company, and they have to appreciate your exposure. Then they will fine tune the premium calculation according to your needs. I'm just worried about this requirement that you have fit for purpose, because was there any damage? Was it, what is the issue? Do you have an example that you want to share with me where it was not, did not meet the fit for purpose requirement?
No. You see, I mean, I'm not talking about in general after a failure, some problem has occurred. No, but you see, oftentimes I find that these two terms are loosely used by many, and one needs to be very, very careful, because very recently I can share my experience that I was involved in a railway project. I was involved on behalf of the contractor, and the design checking was going on, and the railways, after having scrutinized all the designs, he said, I will give the approval provided you give me a affidavit commitment that your design is fit for purpose, which we refused to give at that time, because we said that firstly, we are not engaged by railways, we are engaged by the contractor. And secondly, we are in the middle of the contract. If you had asked for this kind of a certification, you should have asked right in the beginning. Then I would have built my fees covering this risk. So I'm just asking, because this kind of things can come in, anytime.
Okay. So it gets very complicated. I rather not go and deliberate this here. We can talk about it over a cup of coffee. Mr. Alok?
Okay. Thank you.
Thank you.
So next question from Mr. Prabhati Bhattacharya. If consulting engineering organization subcontracts design to another organization, then how will PI policy coverage work? Who should buy the PI, subcontracting designer or main design organization? And who will benefit?
So it's up to the arrangement. Each can buy, or one party, they decide who so and so to buy. And also, is it totally a subcontract or part subcontract? So there's a few things to clarify. I would try to suggest that both parties have to buy PI, because the lead consultant has also some responsibility and some work. And when there's a claim, who's going to benefit? The contribution clause will come in. So both policies will be triggered. Mr. Alok?
Yeah, thank you. So there is a question from the anonymous attendee. What will be the role of expert witness regarding the claims? Who will appoint the experts? I think
so this is appointed by the loss adjuster. Loss adjuster or insurance company, they will appoint an independent consultant, a forensic scientist. Maybe it's a mechanical issue, maybe a failure of a mechanical coupling. So they appoint a mechanical engineer to do the investigation. Yeah.
Okay, next question. Does PI include arbitration expenses like they do include legal expenses?
Yeah, I think this is depends on the wording, but generally defense cost is taken care by the policy. So I believe defense costs will also include arbitration expenses. Yes. Okay.
Now Mr. Mukund is asking, does premium amount varies from consultant to consultant? I think you mentioned that, yes. It depends upon the experience and the background of the consultant.
Yes.
Then Mr. Durand is asking, if your contract liability specifies 1 million USD and that your annual PI cover you up to 2 million USD, for example, are there cases where you can be claimed against for more than 1 million USD if you are at fault?
Well, I don't understand. So he's got 1 million and 1 million contract liability and annual PI 2 million. No, the client, nobody will know that you have cover up to 2 million and your contract liability will only be 1 million.
1 million.
So you don't have to tell your friends and neighbors about your 2 million cover. So, I don't think, Paul, Mr. Duran's concern shouldn't be there. Nobody knows about your 2 million cover. 2 million cover you have you have a cover with PI with the insurance company. You just keep it in the drawer. Anyway, even you receive a claim, you just send it to the insurance company, let them deal with it. You shouldn't be responding to the claim.
Okay, so there is a question, interesting question from Mr. Girish Wadhwa. There is a case where there is a minor failure in structure. The consultant quickly guides the repairs, but which will have a cost of say $10,000. The client refuses to pay consultant and in fact asks consultant to reimburse repair cost. Can quickly PI help in solving without going under legal cases for arbitration? PI's note here, consultant has quickly agreed to the design flaw.
No, consultant cannot agree to the design flaw. They cannot agree. In whatever legal issues, you cannot admit that you made a mistake. You cannot admit to liability or responsibility. You got to report to insurance company and let them take conduct of the matter. Because if you agree for the responsibility, the insurance company will turn around and say that you're no longer liable. You're not liable. So you should never make deals like this on the ground, hoping for compensation. It's not going to work. Mr. Alok, correct?
Yeah. Okay.
Even if you're driving a car and you meet an accident, if you just pay 100 rupees to the injured victim, that is not allowed because you might be implicated with a bigger claim from a lawyer. So do not make such compensation. Insurance policy will not be happy.
Yeah, good. Thank you. So there is a question from Mr. Pankaj Das. How many years should we take PI for a particular project in which construction period is limited to 2 years? I think this also you answered.
So PI, you just renew every year. You just renew every year because this project is over, but you have other new projects coming up. So you continue your PI forever and ever. Next.
Arpit Parikh says, actually, I feel rates of consultancy services should be charged with PI insurance premium prior to contract agreement. My suggestion. Yes, of course.
Yeah. It's a good idea. Good idea. Yes. Yes.
Akshay Kumar Sahu, when design is not considered perfectly and some accident happens, who will be responsible? Still engineer?
No longer engineer because it's some other factor. Then you will go after the factor. So, for example, it's a construction defect. Let's say it's a material problem. Then you go after somebody else, not the consultant.
Okay.
Yeah.
So I think we have exhausted all the questions.
Yes.
Manoj, if you want to sum it up, we have already crossed 6 p.m.
No, I don't have much to say. Yeah, but I think it was a very interesting talk, and I think there were a lot of questions from audience also, and most of them have been answered. But I think there will still be many questions regarding it. So if the audience want to send some questions through email, they can send it to us, and then we will forward to them to Mr. Kuba Mahalingam, and the reply we will receive, we will forward to them directly. So I think it was a very good presentation, and it was quite informative. And probably we can arrange some more such kind of webinar on this topic, Alok. And I'm really very happy that we have organized, ISTT has organized this kind of a lecture for the benefit of the structural engineers. And I think we as a structural engineer need to learn more about this, and we should take PI as required as per the law, contract, project, or our exposure to the risk. Yes. Thank you from my side.
Thank you, Manoj. Yeah. So I echo what Manoj has said. I think it was a very enlightening presentation by Mr. Kuba Mahalingam. I am much better informed after these 2 hours of this session than before, and I I also take very seriously the suggestion made by Mr. Mahalingam that IAS trustee can also think of, sort of bringing something in the plate for our members. Although we have individual members, but eventually for the benefit of the fraternity as a whole, we can bring in something, we can have more interaction with Mr. Mahalingam and maybe come out with some kind of literature and some kind of, technical papers through which we can educate our engineering fraternity. And if required, have much more interaction, more specific interactions on a case-to-case basis. I think we will first work out internally, and then we will come back to you, Mr. Mahalingam, for future such programs. Thank you very much. And with this, I would like to close this session, and I would thank all the participants who have patiently, stayed back till the end. I see still 74 participants in the participants list. Thank you. And with this, I